Yes, hello everybody. Um, the events of January 6th have proven to be completely unfortunate. And I am not sitting here taking a stand either way. I'm just standing by the law. Um, I happen to be somebody that pled guilty for picketing and parading on Capitol grounds. Although I was a journalist observing the events that day, I felt legally that was my best decision. However, upon my plea of guilty, I also simultaneously opened up a lawsuit against the Capitol Police and the District of Columbia for failing to give us dispersal orders and failing to give a safe exit. In that process, um, I might have opened up a can of worms for the U.S. attorneys and actually have given J6 defendants a real solid way out. So I'm just going to get right to it right here. And this is a motion that the Capitol Police, let's go to the top, that the Capitol Police wrote up right here. Okay. Um, this is a U.S. Capitol Police's motion to dismiss the lawsuit against them. And let's just scroll down to the very bottom here and show you who this is from. This is from a Matthew Graves's office. Okay, this is from Matthew Graves's office and from Assistant U.S. Attorney John Bardo. He seems like a nice guy, but he might have put his foot in his mouth. What we have here is what's going on is basically the police in most situations have to give you a warning that you're trespassing. They have to let you know that this has gone beyond protest. This is now a riot. This is an unlawful gathering, and you must disperse. Mayor Bowser had complete access to all of our cell phones and did not give us dispersal orders. And the Capitol Police did not know what to do and did not give people dispersal orders. And this is the reason why so many people went into the building. Now, they were completely indifferent towards our First Amendment rights, and they are continuing to be completely indifferent toward the First Amendment rights because the Department of Justice is now hiding behind the sovereign immunity doctrine. And you know what? That's fine. Do that all you want. However, the U.S. Attorney's Office also wrote that the plaintiff is barred from pursuing any claim that would collaterally attack his conviction. Listen, I pled guilty to picketing and parading on Capitol grounds. That does not mean that the Capitol Police and Mayor Bowser didn't throw everyone off, didn't confuse everyone with her 6 o'clock curfew, and the Capitol Police not stopping people from going into the building. So here they say the plaintiff is barred from pursuing any claims that would collaterally attack his conviction. Despite having pled guilty to parading, demonstrating, or picketing in a Capitol building, B. Christmann, plaintiff appears to be asking the court through this lawsuit to vacate his criminal conviction. The court should dismiss the plaintiff's complaint to the extent that a judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction. All J6ers, I need you to get to this document. On page 11 of this document, okay, this is the memorandum. This is in case 122CV02189, Chief Justice Beryl Howell. This is the case. And on page 11 is the statement that says that if this is true, if Mr. Christmann was not given proper dispersal orders as per the law, they then do not have a case against me. And if I could prove this in court, that they did not give any dispersal orders and they did not give us a safe exit, then that would actually invalidate my conviction. And that's why this case can't go through. So, okay, maybe I pled guilty and maybe I pled guilty too soon. And, maybe it's going to be too much of a process to get my conviction pulled, even though the United States Attorney's Office said that, hey, if you didn't give dispersal orders and you didn't give a safe exit unless they damage property and unless they personally attack somebody else, there's no case to be made against them. And this is coming straight out of a U.S. attorney's mouth out of Washington, D.C., who's representing the Capitol Police. If you use this document, you have a very strong case if you're one of the people that were either engaged in journalism or one of the people that were just observing what was going on that day, or one of the people that was just following the crowd and meandering through the building and not given a safe exit. This is very, very big, and we need to get this word out here. Again, this is coming from Matt Graves's office. Let's get up here and read this one more time, okay? Plaintiff is barred from pursuing any claims that would collaterally attack his conviction. Despite having pled guilty to picketing and parading, okay, fine. The court should dismiss the plaintiff's complaint to the extent that the judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction. Okay. Additionally, the plaintiff cannot obtain injunctive relief to vacate his conviction because it is well settled that a convict seeking relief for his conviction or sentence may not bring such an action. This is a crazy law. This is something that should be brought to Congress and changed. That if you're convicted, you still don't have constitutional rights. Absolutely ridiculous. But we have a real thing here. This is a real thing. This is something that is written again by the U.S. Attorney's Office, and that says that the court should dismiss the plaintiff's complaint because a judgment in favor of the they didn't say no, they should vacate this because we have more than enough evidence to show that there was dispersal orders. There were no dispersal orders. There was nobody in command at the time besides Mayor Bowser. The Capitol Police didn't know what to do, and they stood there and they watched people come in and out of the building and were completely indifferent. Okay, that's the bottom line. That's what happened. Let's go through a quick timeline right here. Let's go to what actually happened on January 6th that day. Okay. Mayor Bowser on January 2nd, 2022, testifies to the select committee that she was desperately trying to get a hold of Capitol Police Chief Thund of the Capitol Police, and at around 2:26, the mayor claimed that Chief Thund was busy with Congress, and at this point, at approximately 2:26, the mayor testified. She testified. It's not even like it's concrete. At 2:26, the mayor is testifying, no, that building was now my responsibility. She said, I quote, when it became clear to me the building was our responsibility. At this point, Mayor Bowser took on a leadership role of the Capitol, especially interfacing with the public. This quote is found on page blah, 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 blah. Any claim made by the plaintiff was based on the mayor's curfew order and the actions of the Capitol Police and the Metropolitan Police that did not follow First Amendment activity protocol, and especially First Amendment activity after a riot is declared. At 2:52, somebody was smart enough to take a screenshot. 3 minutes earlier, Mayor Bowser issues a citywide curfew for DC for Wednesday, January 6th at 6 p.m. The dismissal motions are based on claiming that the Capitol Police was not the mayor's jurisdiction. Meanwhile, the mayor testified to the Capitol, and at the time in question, the building was their responsibility. The building was Mayor Bowser's responsibility. If you go back to 2017, these cases are held in the District of Columbia, and these are District of Columbia violations and not United States Code violations, by the way. And that should be the case here as well. Now, here on January 5th, 2021, can we blow this up a little bit? Here we go. Honorable Jeffrey Rosen, acting U.S. Attorney General, okay, Secretary of the Army, and Secretary of Defense gets put on alert. The Metropolitan Police is prepared for this week's First Amendment activities. MPD has coordinated with its federal partners, namely the U.S. Police, the Capitol Police, and the U.S. Secret Service, all of whom were regular uniformed personnel protecting federal assets in the District of Columbia. This week, the MPD has an additional logistic support of unarmed members of the DC National Guard who will work under the direction and coordination of the MPD. So even if you're hearing about federal agents that were working in there, everything, Mayor Bowser declared that she is in absolute control of the building. Okay. Um, we are mindful that in 2020, MPD was expected to perform demanding tasks of policing large crowds while working around unidentified blah 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 without proper coordination. Unidentified personnel, in many cases armed, caused confusion among residents and visitors and could become a national security threat with no way for the MPD and federal law enforcement to decipher armed groups. Okay, great. This is huge. Here are cases, Goodwin versus the District of Columbia. This case was won in 2021 after January 6th. According to ACU guidelines, these people are outside the White House when Trump got chased to his bunker. They won $1.8 million in a settlement for not getting dispersal orders and being arrested because the MPD showed a blatant indifference towards their First Amendment right. Well, here we go down here. Here's the law. Okay. Here's the law according to the Constitution. Okay. On January 6th, 2021. Okay. Shutting down a protest through a dispersal order must be law enforcement's last resort. Police may not break up a gathering unless it's clear and present danger of a riot, disorder, interference with traffic, or immediate threat to public safety. See, they didn't shut down the protests. They didn't give a dispersal order. If the officers issue a dispersal order, they must provide a reasonable opportunity to comply, including sufficient time and clear, unobstructed exit path. Individuals must receive clear, detailed notice of a dispersal order, including how much time they have to disperse, the consequences of failing to disperse, and what clear exit route they can follow before they can be arrested or charged with any crime. There was no exit. There was no safe exit ever established that day. Even the Government Accountability Research Company went into detail showing that there was nobody that established a safe exit. Okay, now we're getting into DC law. Okay, DC law, the handling of a response to First Amendment Assembly's activity should be designed and implemented to carry out the district policy on First Amendment assemblies established 53303. Okay, where participants in the First Amendment Assembly fail to comply at a reasonable time, place, manner, restriction, the MPD shall, to the extent of reasonable possible, first seek to enforce the restrictions through voluntary compliance, and then seek an appropriate to enforce restrictions by issuing citations or by arresting specific non-compliant persons where probable cause to issue a citation or arrest is present. Nothing in this subsection is intended to restrict the authority of the MPD to arrest persons who engage in disorderly conduct or violence directed at persons or property. Where participants in the First Amendment Assembly and others are at location engage in unlawful disorderly conduct, violent towards persons or property, unlawfully threaten violence, the MPD shall, to the extent reasonably possibly, respond by dispersing, controlling, or arresting the persons engaging in such contact, and not by issuing a general order to disperse, thus allowing the First Amendment Assembly to continue. The MPD shall not issue a general order to disperse to participants in the First Assembly except where a significant number of percentage of assembly participants fail to adhere to imposed time, place, and manner restrictions in either the compliance and measures set forth. Okay. A significant number of percentage of assembly participants are engaging in or about to engage in unlawfully disorderly conduct or violence towards persons or property. If and when the MPD determines that a First Amendment assembly or part thereof should be dispersed, the MPD shall issue at least one clearly audible and understandable order to disperse using an amplification system or device and shall provide participants a reasonable and adequate time to disperse and a clear, safe route for dispersal, except for when there's imminent danger of personal injury, significant damage to property. The MPD shall issue multiple dispersal orders. If appropriate, shall issue the orders for multiple locations. The order shall inform persons of a route or routes by which they disperse, and all shall state a refusal to disperse will be subjected to arrest. Basically, unless you're engaged in disorderly conduct, unless you're and disorderly conduct means not listening, right? I'm giving you an order. No, I'm not following you that order. Peace out. There were no orders given to the crowd. Now, the prosecution, they come up with these pictures you supposedly took. There's nothing in this DC law about pictures you supposedly took. There's nothing that they can provide that says, hey, listen, we gave the crowd adequate dispersal orders. We gave the crowd a safe place to exit. The only thing these guys did here, sadly enough, Mayor Bowser, who full well knows what she's doing, okay, sends out a curfew. Mayor Bowser issues a citywide curfew for DC Wednesday, January 6th, starting at 6 p.m. This is at 2:52, okay? This was sent out at 2:49. Ashley Babbitt was shot closer to 240 than she was shot closer to 249. And Mayor Bowser was in command of the building, knew that deadly force was being used in the building, and didn't say, hey, please avoid Capitol grounds. Any unauthorized people on Capitol grounds will be subject to arrest. We need everyone to exit Capitol grounds immediately, and we are implementing a citywide curfew for 6 p.m. They did not give the crowd dispersal orders. They basically told the crowd, hey, you have 3+ hours to hang out and then get out of here. Basically, she needed the National Guard to come in, and she wanted the National Guard to come in and the National Guard clear out the crowd. But what really happened was Trump supporters are so compliant, they laughed when Trump gave a tweet at 4:20 something, and they knew they had to be home by 6 p.m. We are getting gaslit. I sued them. It might be a little too late because I already pled guilty, but I got the U.S. Attorney's Office to write down in a sworn document that if dispersal orders and a safe exit were not provided, then you cannot be charged. Now we need another fighter to come along and bring this to criminal court. And we need these lawyers because, trust me, a lot of these lawyers know about this case. We need these lawyers to step up and present that, hey, actually, this is the law. Okay. You can't make things up as you go along. This is the law. And the Department of Justice has been not just the Capitol Police that day, not just Mayor Bowser, but the people that are seeking your warrants, that are telling you to get your house raided, are not taking a look to see, hey, was this person given proper dispersal orders? Was a cop waving him off? Did the cop tell him not to come in here? Was the cop indifferent as he entered the building? Well, if the cop was indifferent and didn't tell him not to come in the building, and no cops told him to leave the building, he can't be arrested. And if a cop told him to leave the building and he listened, he still can't be arrested. This is huge. We can't sit here as American citizens and allow these lawyers and allow the prosecution, allow the judge, and allow the public to continue on saying that we stormed the Capitol, we did this, we did that, when many of the Capitol police officers didn't know if it was in their jurisdiction or not to keep us out of the Capitol building. and they weren't sure if they could arrest anybody at this time because they needed as much manpower on staff until the 6 o'clock curfew. Well, that right there says, hey, well, you weren't told to leave. You thought you could protest, and you went there and protested. You didn't break any laws. You didn't break any direct orders. You got out of there well before 6 o'clock. You didn't do anything wrong. You don't deserve to be charged. Maybe questioned, right? You went to the Capitol building during an unprecedented riot. Maybe you deserve to be questioned. But if you complied with the orders, you do not deserve to be charged. Not at all. Thank you very much.